Good afternoon. My name is Alena Shautsova. I am an immigration attorney from Brooklyn, New York. In today's Legally Speaking seminar, I would like to talk to you about stop time rule for cancellation of removal. As you're probably aware, certain non-citizens or undocumented people can qualify for cancellation of removal in the United States if they resided for 10 years in the United States, did not commit certain crimes that would disqualify them, can show good moral character, and hardship to certain family members. So one of the requirements for cancellation of removal is that an individual would reside in the United States for 10 years after he or she arrived to the United States. And it doesn't matter how that individual arrived, whether they arrived through a point of entry with a visa or they crossed the border. But what matters here is that how that period of 10 years is calculated. Sometimes the period can be interrupted legally, even though the individual did not leave the United States physically. And this interruption rule is called stop time rule. So for an individual who would like to qualify for cancellation of removal, the stop time rule is very, very important. How can it be triggered? It can be triggered usually by two ways. Way number two is the service of a charging document, a document that called notice to appear or order to show cause on an individual. This is a document that starts the removal or deportation proceedings for an individual in immigration court, or when an individual is arrested for a crime that would disqualify them from cancellation of removal. And subject of this talk is that notice to appear and the service of notice to appear. For years, what was happening is that DHS or Department of Homeland Security or the government that is trying to deport an individual would serve an individual with a notice to appear that would state that the time and place of the hearing, TBD, to be determined. And for years, the government was relying on this notice to stop time for an individual who would like to qualify for cancellation of removal. Interestingly, sometimes a very long period of time would pass from the time an individual would be served with this uncertain notice to appear, this notice to appear that would only contain TBD, to be determined date and place of the removal, and actual notice to appear, or will receive actual notice of a hearing. Very often it can be a year, it can be even more than a year sometimes. Sometimes an individual would never get a notice to appear that would have a certain time and place, but his or her time for cancellation of removal would be lost, would be stopped. Then one individual, a national of Brazil, decided to challenge this in court with his lawyers. And on June 21st, 2018, United States Supreme Court held that when the government is trying to deport an individual and is serving him or her with a notice to appear and would like to use that notice to appear to argue that individual's stop time rule was triggered, government has to place and has to mention specific date and time and place for the hearing to take place. And those notices that only contain TBD cannot be used to calculate individuals' stop time rule. It's very important. It's very important because sometimes an individual will lack a day, literally a day, or a year towards a 10-year period because he or she received or was served with this, TBD notices until the actual notice would come. So for those cases, for those individuals who are served with TBD notices, you really need to know that based on this new ruling from the US Supreme Court, those notices cannot be used to calculate your stop time. An actual notice that contains date, time, and place is the only instrument that can be relied on when you calculate stop time rule and its applicability to your case. As always, you can learn more about cancellation and removal and other topics I'm talking about in my little videos on our website www.shautsova.com. Thank you.